Hi there, nice to have you with us once again. The Tax Administration Act. You heard anything about it? No, neither have I, if you said no to that one. It evidently came around in 2012 and is in place. And I thought it may be interesting, just to get up to speed with it, to invite Caroline Rogers, who is a senior associate in tax at Edward Nathan Sonennbergs. We'll just call them ENS, it's so much easier. Caroline, thanks so much for joining us in the studio, our gorgeous Cape Town studios. Firstly, why did this come about, and what is this thing, this Tax Administration Act?
That's a good question. It's quite recent. It came about, it was promulgated on the 1st of October 2012, and so most of the provisions are in effect from that date, except for a few that still have to come into effect, but those mainly deal with interest. And the reason that it came into effect was that it's been spoken about for a while, and there have been a few drafts that were released, and comments were submitted on the drafts. And the aim is to consolidate all the administrative provisions in the different tax acts. So for example, in the Income Tax Act and the VAT Act, there were provisions dealing with the issuing of assessments and the disputing those assessments. And what SARS has done, what the legislature has done, is to take all those provisions that are common to all the tax acts and try and consolidate them in one act. And
okay, so wait, hang on now. So how many acts or things have they tried to pull together?
Well, all the acts that SARS administers that have administrative provisions, they have tried to pull together. Yes.
So they're just trying to streamline this whole process.
Exactly. And
but no, before you carry on,
sure.
Are they trying to streamline it for SARS benefit or for the taxpayers' benefit?
Well, the intention is stated to be for both. So SARS is given enhanced powers in terms of this act. So there are a lot of new powers that SARS has granted, and it's stated that the taxpayers' rights are clarified and that there's transparency that's been brought about by the act. So there are quite a few draconian powers that SARS has granted, especially in relation to the recovery of tax from individuals. And I'm sure you've heard of the pay now, argue later rule, which is effective. So if an assessment is raised, you have a tax debt due to the state and you have to pay it unless you submit a request to SARS asking for a deferral of that obligation to make payment if you intend disputing the assessment. And if SARS says that's fine, then you don't have to pay. But if they say it's not fine, then you have to pay and fight later.
You see, I have not that I can do anything because it's already been promulgated,
yes.
But I do have a problem with that because I think you would find that there are some people who would claim that they have had assessments raised that are absolutely impractical and impossible for them to pay before they can dispute.
Exactly. So that's something that we've looked a lot at over the recent months, because a lot of people do feel that assessments are raised and that they're unreasonable. So there's no remedy in terms of the act if the decision of the commissioner is that he won't allow deferral of payment. But there's a right in the Constitution to administrative justice, and that's codified in the Promotion of Administrative Justice Act, commonly known as PAJA. And so the taxpayer can go that route if they feel that the commissioner has been unreasonable in his decision.
When you say they can go that route, what do you mean? They then have to go to court?
Well, that's the problem.
Yeah, because that's going to cost you a fortune.
And payment is not suspended while you go to court. So it's as soon as you submit a request for a deferral of payment, payment is suspended, and then you have about 10 business days after SARS has notified you that they're not granting your suspension until SARS can take recovery steps against you. So if you decide to take that challenge SARS's decision in the courts, it doesn't matter, payment is not suspended, even though you disagree with the commissioner's decision.
Okay, but then having said that, SARS does also now have to respond to you.
Yes.
which was a problem in the past,
Yes.
because you could say, I don't agree with this assessment, and not hear from them for months.
Yes. Well, exactly. I mean, in terms of the rules that govern the dispute procedures, SARS did have to reply within a certain number of days, 60 business days, say, for example, when you were objecting to assessment. So I do think it does set out more strictly what is required of SARS. And for example, it's proposed that there's a tax ombudsman that position has been created in Act, and that person has to be appointed to that position within 1 year from 1 October.
I was going to come on to that,
Yes.
because that to me is an important aspect of this Tax Administration
Yes.
Act.
Yes.
Is this ombudsman? What is her or his role going to be?
Well, you see, that's also got its issues. It's very encouraging that there will be a tax ombudsman, but it will be staffed by SARS, people from SARS. It's funded by SARS, and the decisions of the tax ombudsman are not binding on SARS. So what the tax ombudsman is there to do is to try and resolve issues that taxpayers are having with SARS, but only in relation to procedural and administrative issues. And what will happen first is that the taxpayer has to exhaust all the internal remedies at SARS before they can approach the tax ombudsman. And the tax ombudsman is there to be between SARS and the public protector. And so the first step would be for the taxpayer to phone the call centre or walk into a branch office. The second step would be to raise it to a senior manager level at SARS, or a special special resolution committee. And then the last step would be to go to the SARS monitoring office. And if that doesn't work, then the taxpayer is allowed to raise it with the tax ombudsman.
But then the ombudsman, to me, then seems to be more of an advisory role to
Exactly.
both the public and to
Yes.
SARS, because he can't make any decisions, or
No,
she.
well, they can make recommendations, and
But as you say, SARS doesn't have
it's
to
not
follow those
binding.
recommendations.
But what the legislature did say when it was commented on and challenged, they said what the tax ombudsman does have to do is submit reports to SARS on an annual and biannual basis, quarterly basis, and sort of highlight the 10 biggest cases that they've dealt with where there were the most serious issues. And the legislature's comment is that this will motivate SARS to not abuse their powers.
I suppose it would be a little bit then like, and I'm trying to think of my industry or our industry here in the media, where
Yes.
if I swore on this show and called SARS names,
Yeah.
they could complain to the Broadcast Complaints Commission, which really just makes recommendations, but the Broadcast Complaints Commission's report is attached. The Broadcast Complaints Commission is enacted as an act of Parliament through the Independent Communications Authority of South Africa. Okay. And the Broadcast Complaints Commission's annual report, is attached to the ICASA report, which goes to Parliament. So the legislature, the legislature would be seeing the ombudsman's not objections, but they would be able to get some sort of guidance as to where SARS may be bullying, for want of a better word.
Exactly. And I mean, the Tax Administration Act does go a long way to clarifying the taxpayers' rights and SARS's rights and powers. And so I do think it's a step in the right direction. But it's just unfortunate that the Tax Ombudsman's decisions aren't binding.
How long did this whole process take to try and pull these various acts together? And what sort of input did people like yourselves have? I mean, because you deal with this on a daily basis.
Well, it's taken a number of years. I mean, for example, just dealing with ideas like the Tax Ombudsman, that was initially proposed in 2005 in the CATS report. Mm-hmm. And what practitioners like ourselves did was look at the drafts, consider the issues, and then submit our comments to to the legislature, which were taken into consideration. For example, there was which is a very interesting matter that's arisen, is the application of professional legal privilege in the Act, and whether it can apply to accountants in addition to
what
lawyers.
What does that mean?
So, legal professional privilege is the privilege that a person can claim in relation to their communications with a legal advisor. And so what the rationale behind legal privilege is that it enhances the administration of justice, because a client can feel free to disclose anything to their lawyer who represents them in this system.
So I can come to you and say, I've got a problem. SARS says I owe them X amount of money, and I don't believe I do.
Yes.
But what I have done is I did schmuchel this little thing over here, and that was sort of, if you look under there, under that bed, and that communication between you and I is aside.
Yes. And communications from your lawyer regarding a tax structure is also, SARS can't request that information. And a very interesting case arose in England, and our law of evidence actually is derived from the English law.
Right.
So their decisions are quite persuasive, and it went all the way to the Supreme Court, to the Prudential case. And what had happened was that a group of tax advisors had advised the client on a tax structure, and they were trying to claim privilege and said that the Revenue Service could not access that advice, and the court held that professional legal privilege does not extend to accountants, and that it's actually up to the legislature to make that policy decision and extend it. And then coming back to comments submitted on the Act, there were comments submitted and recommendations made to the legislature that that privilege be extended in the Act to cover professional tax practitioners.
And that was accepted?
No, it wasn't.
Oh.
So the presentation to the Standing Committee on Finance on comments made to the bill was that it's not applied consistently overseas, that sort of there are different jurisdictions that do legislatively allow privilege to be extended to certain professionals who are not lawyers, but that it's not a consistent application. Also that lawyers we're regulated by the courts and by our administrative bodies.
But aren't tax consultants administered by regulations as well?
Yeah, but they're self-administered. So
I can't tell you that I schmucheled this year and under this bed I've got this.
Well, if I was an accountant, you shouldn't. I mean, you shouldn't be smuggling anyway. Let me just clarify. But if perchance you accidentally left out an amount on your return and you devastated when you found out and came straight away to me, and I'm a lawyer, I won't, SARS can't ask me for that information.
Okay.